No, I'm just early. Hey now,
Morning.
how are you?
Good. You? Good morning. What happened to you?
I had heart surgery yesterday.
You did? What are
Yeah.
you doing here?
I feel fine.
Really?
Yeah.
What kind of heart surgery?
They, 3 years ago, I had my heart stopped, and there was no warning or anything. So they did a stress test a couple weeks ago and said, well, you might have a blockage. We can't be sure, and because we don't get warnings, we're going to have to go in. So they went in, they put a hole in an artery, and went in and looked, and
What'd they find out?
well, I had 100% blockage, but my heart made its own bypass around it.
Whoa.
And
That's
they said,
interesting.
so they checked the 3 stents they put in 3 years ago. They're good, and they said your heart made its own passageway, and
Well, you know about that?
so the only thing I'm not allowed to bend my wrist because
Oh, because of the.
because the hole in the artery, you know.
Mhm.
He said, oh, you'll bleed out. So
Okay, don't do it on my watch.
so I gotta have this on, but I feel fine. I was awake for the whole thing, and oh yeah, I could.
Where'd you have it done? Sarasota?
Peace River Cardiovascular.
You didn't even go to the hospital?
Oh no, they did it in an office.
Oh my God.
It's wild. You could feel, I could feel them putting the thing up through my arm and
Oh
down
my
into my
God.
heart.
Oh my God.
It was weird.
Oh, this is giving me the chills.
And the doctor's talking to me the whole time,
Oh my God.
and she's a kid. I mean, she's a young lady. When the first time I met her, because it was COVID was then, but you know, I really had this mask. And the first time I saw her with a mask on, I said, "Oh my God, what's the matter?" I said, "You're a kid." She goes, "I saved your life." I said, "You sure did." Great doctor, great lady.
Wow, what's her name?
Dr. Stratton, Melanie Stratton,
Okay.
and
Is she affiliated with any group?
she's affiliated. Well, there's 4 cardiac physicians together. She's like the lead, I think, of them all, and I think either she is or was a temporary chief of staff for cardiology at the hospital over there.
You mean in Port Charlotte?
Yeah.
So that's Advent now? Or
Yes.
the other hospital?
Yes.
Oh, good, okay.
So,
Hi, good morning.
great lady.
Good to know, because my husband's looking for a cardiologist and he likes Advent, so.
Oh, I would recommend her to anyone.
Melanie Stratton.
Yes, Dr. Melanie Stratton.
You know, my mother was always a big believer in always get a younger doctor.
Well, they're the most,
They're
well,
up to date. if the shape is open, you can see it right there. We're sitting in the harbor walk.
Oh, there he is.
Are you ready, Brad?
Lewis, Mr. Lewis. I want to say Daniel Lewis, but he's the actor. Yeah.
We're ready whenever you guys are.
Okay, I guess we are ready. 'Cause it says name. All right. Good morning. This session of the Punta Gorda Code Enforcement Board is called to order. Will the clerk please conduct the roll?
Keith Johnson,
Here.
Carl Rich,
Here.
Joseph Como,
Here.
Kathleen Antona,
Here.
Robert Englehart, Mark Hatala, Adele Higgins,
Here?
Ronald Mouchon.
Present.
Thank you.
Thank you. All right, the next meeting of the board will be here at the Lashley Community Room on Wednesday, May 28th, also at 9 a.m. The first item of business on our agenda is the approval of the minutes. Has everyone had an opportunity to review the minutes?
Yes. Yes.
Is there any discussion necessary? All right, I will entertain a motion.
Bouchon so moves.
To approve the minutes? All right, is there a second?
I'll second.
Any discussion? All in favor signify by saying aye.
Aye.
Any opposition? The motion carries. The minutes of the March meeting are approved. The first item of business on the agenda is board training. Because there are cases that will be heard, I would suggest that we move the training till after the cases to enable people who might be present to have a case heard, the opportunity to have their case heard and then leave. Is there any discussion, any consensus on the part of the board regarding that? Everybody okay with moving the training? All right, we're going to move the training then to the end of the meeting after unfinished business. All right, then the first item, but before we do the cases, can we have the witnesses sworn?
Anyone intending to provide testimony in today's proceedings, please stand and raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth in today's proceedings? Yes. When you approach the podium, please state your name and indicate you have been sworn.
All right, thank you. The first item is hearing in case number 25-87353, Code Compliance Officer Frank Coppinger, Respondent William Dominic Marcella III, address of violation 509 Palm Avenue, violations alleged, Chapter 26, Section 1.4, no permit, Chapter 26, Section 1.5, no permit, Chapter 26, Section 1.10, no permit. Is the respondent present? Is the respondent present? The respondent not being present, I will enter a plea of not guilty on behalf of the respondent. Mr. Coppinger, I presume.
Yes.
Good morning, Mr.
Good morning.
Coppinger. Welcome. Are you one of the new code compliance officers?
Yes, I am. Approximately about a month into my tenure.
Congratulations.
Thank you very much. Pleasure to meet you.
Go right ahead.
Frank Coppinger, Code Compliance Officer for the City of Punta Gorda, and I have been sworn. According to Charlotte County Property Appraisal records, the property located at 509 Palm Avenue is within the city limits of the City of Punta Gorda, Florida, and the property is owned by the respondent. I am submitting 7 photos for the record. The pictures submitted for evidence are true and accurate representation of the site at the time the pictures were taken. On January 30th, 2025, an inspection of the property and building department records by Code Compliance Supervisor Nick Faulkner found that the fence on the rear yard of the property was installed without obtaining a fence permit, which is in violation of Punta Gorda Code, Chapter 26, Section 1.4, Chapter 26, Section 1.5, and Chapter 26, Section 1.10. On January 30th, 2025, a notice of violation of order for corrective action was sent to the respondent ordering corrective actions be taken and a fence permit application be submitted and obtained within 21 days of receipt of the notice. On February 12th, 2025, the notice of violation and order for corrective action was received by the respondent via certified mail. On March 19th, 2025, I re-inspected the property and found that the violations have not been corrected and that the fence on the rear yard of the property was installed without obtaining a fence permit and remains on the property. On March 19th, 2025, a notice of hearing was sent to the respondent via certified return receipt mail, which was delivered to the respondent on April 2nd, 2025. On April 22nd, 2025, a re-inspection of the property and building department records by Code Compliance Supervisor Nick Faulkner found that the fence permit has been applied for and obtained. However, the fence has not had a final inspection to ensure the fence is within city code regulations. I am submitting case costs incurred in the amount of $15.93.
Are there any questions from the board?
Mr. Coppinger, I apologize. I was distracted for the moment. The date that the permit, you said it was obtained. The permit was obtained, but it has not completed final inspection, correct?
Correct.
Could you give me the date of those again, please?
The date of the application was on March 20th, 2025.
Thank you.
Can you tell me what, on the pictures, there's some red labels on the fence? Are those the company name?
I believe so.
I'd like to make a motion.
I have a question. So the fence has been installed, the permit is applied for, the permit was approved?
Yes,
correct?
it was.
And we're just waiting for the final inspection.
Correct.
Has that been scheduled, to your knowledge?
No.
That's the city's responsibility, correct? The inspection.
The respondent or the company needs to request it.
So whose court is the ball in right now?
The
The
respondent.
city's or the respondent?
The respondent.
The respondent? Okay, thank you.
I can make a motion, the city has established a prima facie case.
Is there a second?
I'll
Second.
Any discussion? All in favor signify by saying aye.
Aye.
Any opposition? Motion carries. The board has found that the city, that the city has established a prima facie case regarding the violations. Before we move on, Mr. Coppinger, why are there three different permit sections alleged? I mean, code sections alleged? Do you know?
Nick Faulkner, Code Supervisor, and I've been sworn. All three code sections Section 1.4 is applicability, Section 1.5 is compliance, and Section 1.10 is permits and certificates. Each one is relevant for getting a permit with the city in regards to a fence, a sign, what regularly comes to our office.
Okay.
So it's one violation with three applicable sections?
Correct.
Okay, so the board should then find that the city has established a prima facie case as to all three sections?
Correct.
All right, is there any need to amend the motion? We'll just make it clear. Yeah.
And I can
Yeah.
repeat the motion again if you like.
No, I don't think that's necessary. Let's just make it clear that the city has established a prima facie case as to all three sections.
Yes.
All right? Is there any further discussion or further testimony? All right, I'll entertain a motion.
I'll make a motion.
Okay?
I'll make a motion to find that the respondent violated Chapter 26, Section 1.4 of the Punta Gorda Code, Chapter 26, Section 1.5 of the Punta Gorda Code, and and Chapter 26, Section 1.10 of the Punta Gorda Code, and issue a cease and desist order for any future violation of the Punta Gorda Code, Chapter 26, Sections 1.4, 1.5, and 1.10 of the Punta Gorda Code. In order that the respondent bring the property into compliance within 30 days of the receipt of this order. Further ordered that the respondent required to pay case costs incurred in the amount of $15.93 within 14 days of receipt of this order. Further ordered that failure to comply with the order may cause the Code Enforcement Board to impose a fine of up to $250 per day, plus applicable interest. And I am, just for edification of the board, use 30 days because fence has been approved. Everything's ready to go. I believe the respondent should have adequate time, 30 days to get it.
Second the motion.
Is there any
Madam Chair?
Yes.
Some new information has come to light. I just
Okay.
checked the building department records for their inspection assignments, and 509 Palm Avenue, the fence inspection is scheduled for today. So if we go out and the fence does meet the parameters of our code, then we would close the case, or we would close the inspection, and the building department would close the permit, which would essentially close our case. But if we go out and the fence is 7 foot tall instead of 6, then we still have an issue.
All right, and is the material, I'm sure, I don't know if you can tell from the photos, is the material an acceptable material for a
Yes.
fence?
Yes.
We'll continue with that motion, though. That gives us the chance. 30 days is plenty of time, just in case something doesn't quite meet standards.
Okay.
Okay, and nonetheless, the costs would be applicable.
Yes.
All right. All right, there's been a motion and a second, and we're informed that the inspection is today. And you wish to renew the motion, right, Ms.
Yes,
Santana?
I will renew that motion.
All right, and there's a second? And there's a second from Mr. Rich. Any discussion? All those in favor signify by saying aye.
Aye.
Any opposition? The motion carries. The board has found that the respondent violated Chapter 26, Sections 1.4, 1.5, and 1.10 of the Punta Gorda Code, and issues a cease and desist order for any future violations of these code sections, and orders that the respondent bring the property into compliance within 30 days of receipt of the order, and it is further ordered the respondent be required to pay case costs incurred in the amount of $15.93 within 14 days of receipt of the order, and further ordered that failure to comply with the board's order may cause the Code Enforcement Board to impose a fine of up to $250 per day, plus applicable interest. Thank you. Thank you, Mr. Coppinger. All right, the next case is a hearing in case number 24-86638, Code Compliance Supervisor Nick Faulkner, respondent Jesus Garcia and Ann M. Suris, address of violation 470 Bal Harbor Boulevard, violation of Chapter 26, Section 8.11A, property maintenance roof. I understand that the city has a motion.
Nick Faulkner, Code Compliance Supervisor. I've been sworn. Yes, we are motioning to continue this case to the May 28, 2025 Code Board meeting.
And the reason for the motion?
They have, I've talked to the respondent. They have gathered the permit for the roof, and they just need a little more time.
Okay, so they concur with the motion to continue.
Yes.
All right. All right, the city has made a motion. Let's vote on the city's motion, whether to approve or deny. All in favor of approving the city's motion signify by saying aye.
Aye.
Any opposition? The motion carries. The motion is approved to continue this matter to the May 28, 2025 Code Board meeting. Thank you. All right, the next item is hearing in the case number 24-86858, Code Compliance Officer Frank Coppinger, respondent 24/7 Automotive Performance LLC, care of Christopher Chase, Address of violation, 415 Cooper Street. Alleged violations, Chapter 26, Section 8.5B to F, fence in disrepair. Chapter 26, Section 8.10, multiple axle trailer. And violation of Chapter 9, Section 9-2A, outside storage. I understand the city has a motion.
Yep, Nick Faulkner, Code Compliance Supervisor, I've been sworn. Motion to continue to the May 28th, 2025 Code Board meeting.
And the reason for the motion?
We're working with the property owner. They've made some steps in getting into compliance.
All right, so the property owner joins in this motion?
Yes.
Okay. All right, the city has made a motion, which the board will consider. All in favor of approving the city's motion, signify by saying aye.
Aye.
Any opposition? The motion carries. This matter is then continued to the May 28, 2025 board meeting. Okay, the next item is hearing case number 24-86868. Code Compliance Officer Nick Faulkner, Respondent Curtis L. and Sherry Fulham. Address of violation 2489 Flora Lane. Alleged violation is Chapter 26, Section 8.11A, property maintenance roof. I understand the city has a motion. Mr.
Nick Faulkner, Code Compliance Supervisor, I've been sworn. Motion to dismiss. The property is in compliance.
All right. Is there any discussion? I'll ask for a vote on the city's motion. All in favor, signify.
Aye.
Any opposition? The motion carries. The board approves the city's motion to dismiss. Thank you. Next item, case number 24-86332, Code Compliance Officer Nick Faulkner, Respondent Nancy Hoagland Morrissey, address of violation 1640 Via Bianca, alleged violation Chapter 26, Section 3.13 N 1, 2, 3, 4, and 5, fences, walls, hedges. I understand the city has a motion.
Nick Faulkner, Code Compliance Supervisor, I've been sworn. Motion to dismiss. The property is in compliance.
Excellent. All right, the city's motion will be considered. All in favor signify by saying aye.
Aye.
Any opposition? The motion carries. The city's motion is approved. This matter is dismissed. Next item is a hearing in case number 24-86866, Code Compliance Supervisor Nick Faulkner, Respondent Britt Properties LLC, address of violation 821 West Marion Avenue, alleged violations Chapter 26, Section 16.5C1, demolition requirements, violation of Chapter 26, Section 16.5G, demolition requirements, and Chapter 9, Section 9-2H, tall grass and/or weeds. Is the respondent present? Is the respondent present? All right, the respondent not being present, the board will enter a plea of not guilty on the respondent's behalf. Officer Faulkner.
Nick Faulkner, Code Compliance Supervisor for the City of Punta Gorda, and I have been sworn. According to the Charlotte County Property Appraiser's records, the property located at 821 West Marion Avenue is within the city limits of the City of Punta Gorda, Florida, and the property is owned by the respondents. I'm submitting 17 photos for the record. The pictures submitted for evidence are a true and accurate representation of the site at the time the pictures were taken. On September 17, 2024, I inspected the property and found that after the demolition of a single-family residence on the property, the demolition requirements have not been achieved, and the shadow box fence structure remains on the property, which is a violation of the Punta Gorda Code, Chapter 26, Section 16.5C1, and Chapter 26, Section 16.5G. And we find that there is tall grass and or weeds throughout the property, which is a violation of the Punta Gorda Code, Chapter 9, Section 9-2H. On September 19, 2024, the notice of violation order corrective action was sent to the respondents ordering corrective action be taken and the shadow box fence structure be removed within 30 days of receipt of the notice, and the tall grass and or weeds be mowed, trimmed, and maintained within 5 days of receipt of the notice, and the property be restored and stabilized by sodding or seeding as to adhere to demolition requirements. On October 1st, 2024, the notice of violation order corrective action was returned undelivered. On October 1st, 2024, I posted the notice of violation and order corrective action on the property and at City Hall Annex. On March 19th, 2025, I re-inspected the property and found that the property had been stabilized and the grass and/or weeds exceeding 12 inches in height had been mowed, trimmed, and maintained. However, the violations have not been corrected and that the demolition requirements have not been achieved, and the shadow box fence structure remains on the property, and the property had not been sodded or seeded. On March 20th, 2025, a notice of hearing was sent to the respondents via certified return receipt mail, which was returned undelivered on April 3rd, 2025. On April 4th, 2025, I posted said notice of hearing on the property and at City Hall Annex. On April 22nd, 2025, I re-inspected the property and found that the violations had not been corrected and that the demolition requirements had not been achieved, and the shadow box fence structure remains on the property. The tall grass and/or weeds exceeding 12 inches in height have returned, and the property had not been sodded or seeded. I'm submitting case cost incurred in the amount of $28.62.
Questions from the board?
I do, but I don't know what the question is. So looking at the pictures, it looks like there's a driveway that would have been either concrete or macadam, and that needs to be removed as part of the,
That's correct. That's part of the
Demolition.
demolition requirements, correct?
so the fence, the driveway, and then the lot needs to be seeded
Correct.
or sodded.
Yeah.
Okay,
We would accept strip sod as well.
okay.
But it also looks like there's a slab remaining. Or is that just hard pan?
Can you show me what you're talking about on the pictures?
Yeah, I thought that was hard sand.
Oh
At
yeah,
the- At the end of the
that was
driveway.
part of the stabilization. Was to fill the,
All of this that you see in here needs to be turned and seeded then.
yes,
So that's actually dirt and not concrete.
yes,
And all of the notices have been returned undelivered, is that right?
that's correct.
Is that a permit on one of the posts there?
Yeah, they did achieve, or they did receive a demolition permit to demo the house, but they have not done a final inspection of that demo.
Okay.
And if the property is in violation twice of the tall grass, don't they automatically go into the lot mowing program?
As the lots is, what it looks like now, it would be ineligible for the lot mowing program because of the fence structure and how it
Okay.
appears.
Interesting. And all of these, and the demolition of the house predated last year's hurricanes?
The application for the demolition was submitted February 23rd of 2023.
Wow.
The notice of commencement was February 20th of 2024, and building did a final inspection on April 15th, 2024.
So the building came down between April and September of 2024?
Well, building did a final on April 15th, 2024, and that was their last inspection, so
That meant the building was down by then?
yes.
Okay, thank you.
So this is Hurricane Ian. It has nothing to do with last year's events.
Don't know if
It would go back that far.
it's...
Yeah,
Hurricane Ian was 2022.
yeah.
The application for the demo was February 23rd, 2023.
I'd like to make a motion, the city is established a prima facie case.
Is there a second?
Second.
Any discussion? All in favor signify by saying aye.
Aye.
Any opposition? The motion carries. The city has established a prima facie case regarding these alleged code violations. Is there any further evidence or discussion necessary? I have a question about notice. I know that all of the notices were returned undelivered. This is, obviously it's a vacant lot. Where were the notices sent?
Hang on, we'll check property appraiser records for that. It was sent to Britt Properties LLC. Its address is 6424 7th Avenue North, St. Petersburg, Florida.
Thank you.
And there has been no further communications with them.
I have had contact with the property owner. The reason that the property has not been brought into compliance after the single-family demolition was his plans are to submit building permits to rebuild. You have a 6-month window to do that after the demolition. Obviously, that has not been met, so which required us to open a case.
Got it.
And currently, there's no building permit for this property.
So now you've spiked my curiosity, had he obtained a permit, then he would be considered in compliance right now.
We would still keep the case open because people can open up building permits and do nothing. So we'd still have the case open if 6 months went by and no building or construction has commenced, then it would still be an open case.
And we would be right here with this?
Yes.
I'd like to make a motion.
Well, I've got one more curiosity as
Okay.
as the subject of vacant lots and requirements for grass and all, percolate about the city. So this is a violation for tall grass and or weeds. Is there no violation then for him having, or where would the requirement for him, like some of the other vacant lots to seed or whatever, come into play? Is that also required that, or is it not required because nobody's parking on it?
The seed and sod is a part of the demolition requirement for after the demolition of a single-family residence. That's located in the chapter.
Okay, that's part of the
Yes.
chapter 26, section 16.5.
16.5G. That's correct.
Okay.
Okay,
Ready for a
Okay.
motion?
I'm ready for a motion.
I'd like to make a motion, Rich, that the respondent violated Chapter 26, Section 16.5, Charlie 1 of the Punta Gorda Code, Chapter 26, Section 16.5, Golf of the Punta Gorda Code, and Chapter 9, Section 9-2, Hotel of the Punta Gorda Code, and issue a cease and desist order for any future violations of the Punta Gorda Code, Chapter 26, Section 16.5, Charlie 1, Chapter 26, Section 16.5 Golf, and Chapter 9, Section 9-2 Hotel of the Punta Gorda Code, and order that the respondent bring the property into compliance within 60 days of receipt of this order. It is further ordered that the respondent is required to pay case costs incurred in the amount of $28.62 within 30 days of receipt of this order. And it is further ordered that failure to comply with this order may cause the Code Enforcement Board to impose a fine of up to $250 per day plus applicable interest.
Is there a second?
I'll second the motion.
All right, Mr. Rich, could you articulate why you selected 60 days?
60 days because I think with the amount of effort it might require to get his plans approved and the permit issued, it could be, if he goes for his application and they ask for a change, so rather than see him back here and go through it again, I thought 2 months would be enough time to get through the issue.
All right. Okay, there's been a motion and a second. Any further discussion? All in favor signify by saying aye.
Aye.
Any opposition? The motion carries. The board has found the respondent has violated the following chapters. Chapter 26, Section 16.5C1, Chapter 26, Section 16.5G, and Chapter 9, Section 9-2H of the Punta Gorda Code, and issues a cease and desist order for any future violations of the Punta Gorda Code sections, and orders that the respondent bring the property into compliance within 60 days of receipt of the order, and further order the respondent be required to pay case costs incurred in the amount of $28.62 within 30 days of receipt of the order, and further ordered that failure to comply with the order may cause the Code Enforcement Board to impose a fine of up to $250 per day, plus applicable interest. Thank you. All right, that completes the agenda for new business. Is there any unfinished business? All right, and if there's no unfinished business, we'll proceed to training.
All right. Good morning, Code Enforcement Board. Deputy City Clerk Jennifer Faulkner. I know this is everybody's favorite meeting of the year. We have revamped the training slides a little bit to focus more specifically on the quasi-judicial hearing procedures. So we're going to go over in a little bit more detail than usual the different types of hearings that typically come before the board and review the order of operations for those. We will also touch on sunshine law, public records law, and ethics. A lot of the stuff that we used to go over, we decided that those types of things, expectations, obviously there's going to be slides on those, but we felt that the substantive information that we wanted the board to be refreshed on was the hearing procedures, the sunshine law, those types of things. So if I go too quickly through any of the sort of introductory slides, please let me know. But most of that stuff you are familiar with, and any procedures that you are following and are doing right, we're not going to harp on, obviously because you don't need a refresher on those. So like I said, if I'm going too quickly through anything, please let me know, but I did want to kind of give you a heads up on terms of what we're going to be primarily focusing on in this training. Okay. All right. So like I said, this is just kind of a list of the things we'll talk about. Most of the focus is going to be on that quasi-judicial hearing section, and then the applicable state statutes under sunshine law, public records law, and the ethics laws that apply to this board. This is just a quick list of, I know we had chair and vice chair elections in February, so you got a training on the chair responsibilities and procedures then. I did want to point out just on this slide, the one bolded section, that something we would really encourage the chair, and in their absence the vice chair, to do is to assist staff with enforcement of the sunshine laws and the quasi-judicial hearing procedures in the event that we start getting into a place where there is either confusion in the process or the discussion is veering off into an irrelevant place. We would encourage the chair as the driver of the meeting to assist staff with making sure we're on track. Okay. And then expectations of the board members. Just want to point out a couple of the bolded items here to speak clearly and audibly into the microphones. I think that overall this setup is a lot clearer on the audio and video record than we have had at the Heritage Museum, but we do still encourage the board members to be aware that we want their comments on the record, so please make sure that you're speaking directly into the microphone and in a volume loud enough that it could be heard by someone standing in the back of the room. Then the other bolded item here is just to refrain from engaging in sidebar conversations. We'll get into this a little bit more when we get to the sunshine law slides, but just as a reminder that it is not only the practice of the sunshine law, but also the appearance of practicing the sunshine law or adhering to the sunshine law. So we encourage all of the board members to be mindful of that. And if you are making comments or asking questions during the course of a board meeting, just ask them into the microphone and then allow, the appropriate staff or board attorney or whoever to respond to those. Even if it's something like, sorry, what page are we on in the agenda packet, or what was that number for the case cost, something like that. Go ahead and ask that into the microphone as opposed to the person sitting next to you. Okay. And then this board does have alternates, so we have a couple of slides here on the expectations of the alternates, which you all have received in previous trainings. Just a quick reminder in terms of how this board interacts with city staff. The clerk's office provides the board recorder, Alex. We also handle sort of the major oversight functions of the board, including board appointments, tracking attendance, providing training and educational materials. And then for your sort of day-to-day contact, it's the urban design department, the code compliance division. So your board secretary, quote unquote, is Ashley Carney, who's the administrative assistant with the code division. Her information is there. She's really the one that you need to be letting know if you're going to be absent from a meeting, if you have questions about agenda materials, if you need to obtain copies of agenda materials, that sort of thing. You go to Ashley for that. Okay? And then just a brief reminder about the quorum and the absence policy. This being a 7-member board, your quorum number is 4. And that is based on the number of appointed members. So in the event that there were vacancies, obviously that might change because we are going to be basing that quorum number on number of appointed members as opposed to the number of members that the board holds, if that makes sense. It hasn't really been an issue with this board because it's been fully staffed essentially, but that has come up in other boards, so just wanted to point that
I
out.
have a question for you.
Sure.
I presented to the city attorney at the February meeting, and he did not have an answer for me, and that was if you had a minimum members present, a quorum of 4, and one of the members had to recuse themselves, would that nullify the quorum? And according to this, it would. You could not take action on that.
It is my understanding that yes, the quorum number needs to be maintained throughout the meeting, and if you had a situation or a case where a member that was sitting on the dais recused themselves either because of a conflict of interest or because of a due process issue, and there was not another member or alternate available to sit in for that member for that case, and that reduced the quorum number below the minimum, then yes, the board would, on that particular item, only be able to take those limited actions that are available when the board
So
loses
then
a
a proper
quorum.
procedure would be for that item to be tabled to the next meeting or when there was a quorum.
Dan, do you want to? Sure. Dan Lewis, the board attorney, can give you a little bit more on that. Thanks, Dan.
Yeah. So yes, if what would make me feel most comfortable, I'll put it that way too, because a lot of all boards they have varying rules based on their charter. However, I don't want this board to get into a situation where we're exactly where we have, where now we have our bare minimum quorum, and because of a voting conflict, we have less than a bare minimum quorum deciding on the matter. My recommendation, if we were in that situation, is to put it to the next meeting for that very reason. Because honestly, at the end of the day, it's safer for you all.
Sure.
Thank you.
Yep.
And thank you for that question, Mr. Mushong. I'm glad we were able to get that addressed at this meeting. The other thing I wanted to remind you all of on this slide is the absence policy. Under the bylaws, which really are based on Chapter 162 of Florida statute, and for the city advisory boards as a whole, we do not currently have a process in place that allows for or that makes a distinction between excused and unexcused absences for the board. The absence policy is that a failure to attend 3 meetings in a 12-month period automatically forfeits your seat, and then there is an appeal procedure where you can submit a letter requesting to be reinstated. That goes before the city council for review and approval. So just wanted to remind everybody of that policy. Okay, and then we're going to start going through just a few reminders on each on the general meeting procedures in each of the agenda sections. If there's anything on these slides that you want me to go over specifically, please let me know. Otherwise, I'll just kind of skim through these. Do want to remind everybody that there is not a motion required to adjourn the meeting. Just once all of the agenda items have been addressed and there is no further business, a hit of the gavel and stating that the meeting is adjourned is sufficient. And then under this slide, I just wanted to point out that member comments is if you have things that other items of discussion that you would like to see on a future agenda. For example, if you wanted to review elements of the bylaws, or if you wanted to have a procedural review of hearing procedures or something else like that, anything that you'd like to request to see as a future agenda item other than a code case, because as you all are very well aware, board members are not permitted to initiate code cases. But that would be something that you could discuss under member comments to obtain a consensus to have as a future agenda item, and then that would be coordinated through staff to put that on the agenda and have those materials made available to you. So yes, just as a reminder, under the member comments here, this is also the place where if you wanted to talk about status updates on a case, and I know that we have had some questions about this in the past, so I do want to take a minute and just review the applicable scope here. If as board members, you are going to be asking about status updates on a case, then best practice would have you ask those questions limited to whether or not a respondent has complied with a compliance order entered by the board, and ask for those status updates after that order is final, meaning after the appeal period for that order has passed. And that should really be the umbrella under which your questions fall. Anything outside of that, you are potentially running into a sunshine law violation, a due process violation, those types of things, and we want to make sure that the board's orders and actions are defensible. So if you have questions about a previous case, you can ask questions about to what extent has the respondent adhered to the compliance order that we entered, and staff can provide you that information. Or if you have questions about now, really, and we have gone back and forth on that with the board attorney, just to make sure that we are giving you best practice information and the most defensible information. So we would prefer that you limit your status update questions to what extent has the respondent complied with the compliance order, and ask those questions after the appeal period for that order has passed, so that order is considered final.
Okay, I have a question. First question is, what is the appeal period for board orders?
Mm-hmm.
And a comment that sometimes our questions relate not to cases for which we've issued orders, but cases that have been continued.
Mm-hmm.
So, my sense is that if we ask a question about the status of a case which has been continued, that's basically a procedural question, and there's no due process issue involved. And then I have a second comment, which is, on occasion, we have board orders that have been appealed to the courts.
Mm-hmm.
And on those occasions, we seem to, from a formal standpoint, we seem to lose track of where they are.
Mm-hmm.
And I would have, of course, maybe board members also, would appreciate an occasional update on those cases, the status of those. For example, there's the case involving, is it Emerald Point?
Emerald Lakes.
Yeah, the
Lighting.
lighting case. That's been appealed. I know, it's up to the court when to rule, but it would be nice if every quarter or every 6 months or something, someone would say to us, oh, by the way, the court still hasn't ruled on that.
Sure, and I can let Mr. Lewis comment in more detail. It's my understanding the appeal period is generally 30 days following the entry of the order. And then in terms of the status updates on any pending litigation because of an appeal, or status updates on continuing cases, I'll let him respond to that.
So an appeal of a code enforcement order is 30 days from the date the order is signed, that's an important distinction to always make, because sometimes the date that your order is rendered versus what date the order is signed can be different dates. So it's 30 days from the date that the order is signed, and that is the appeal period to have the courts
Right.
in its appeal capacity. And my point on this one is that you as a board you in your quasi-judicial powers. Again, it's sunshine, but it's also due process, and you cannot at that point. You don't ever want to fall into a trap of asking and requesting information on a case that is not final, that potentially could be before you in a non-public hearing, and especially if it's getting to the point, if you may have to rule on it again, because the thing is, say for Emerald Isles, that case very well could come back to you, because ultimately if the appeal is granted, and I'm not dealing with that case, but for instance, if the judge rules yes for a couple, for whatever reason, it would become, grant the appeal, it would come back to you for determination, depending on what the ruling was. So my point in that is that there could still be matters before, if the appeal period is not closed yet. Because once the appeal period of those 30 days is closed, then that order is final. I don't want to get in a situation where potentially, it could come back before you before that period of time, if there is an appeal put in place. So that's the point of saying it's, status updates. You want to limit it to that.
Right. And the 30-day period it's 30 days from the day the order is signed, not 30 days from the date the order is received. So it's less than 30 days for the respondent to appeal on occasion, correct?
Depending on what day they get it, yes.
Right,
It is,
right.
yes.
I mean,
but
if it takes them a week to get it, then
it is. Rule is 30 days from the date the order is received. And that is to put in your notice of appeal. So in that.
Wait a minute, now I'm confused.
Okay.
30 days from the date the order was signed, is what you said.
Yes.
Okay.
And you have 30 days to put in your notice of appeal from the date the order is signed. Because that's as opposed to what happens is what initiates the case is it's called a notice of appeal. It's basically filing something saying, I'm appealing this.
Appeal, right.
Yeah. It's not that like I'm putting my entire brief in. At that point, they'll give you time the court will give you time to draft your whole brief. And that's why it takes, as someone who has done code enforcement appeals, it does take a long drawn out, it can be a long drawn out process depending how long, depending on what the issues are. I've thankfully only had relatively quick ones, but that still took like 6 months. So, but it's one of those things, until that order is final, so that there's either appeals over really until that period, that time, until that order is final, it could come back to you, and that's what I want to avoid, and that's the kind of the point.
Wait a minute, I'm still confused.
Oh, sorry.
Okay.
I'm sorry. I'm trying to explain it. I'm making it more confused.
I understand that we should not do anything while the appeal, while the party could still appeal.
Right.
Before they make a decision. Let's say for example, using as an example this Emerald Point lighting case.
Okay.
The case is on appeal with the court. I'm assuming because it's on appeal with the court, there is nothing wrong with asking for a status about it.
I would ask a status update on the appeal case.
Yeah.
Yeah, not the actual, and that's what
I don't
facts of
care
the
what
case.
they're doing. I just want to know what the court.
So I'll refine that, and I'll even it's to staff. But if you say, okay, well, what's happening? Because that ultimately that's public record.
Right.
You can go on. That's
right. I'm just asking you to do my homework.
It's so if it's what's the status of it? Is it set for is it set for public? Is it set for oral arguments? Do we have an appeal yet? Do we have an order yet?
Right.
That's fine, but for actual specific facts of the case,
of course not.
No.
Right. I understand. Okay. Thank you.
And
that's
if I
the
need
distinction. I appreciate that.
and I'll clarify. I probably should have clarified that with town staff, so that's on me.
Okay. Good. Thank you.
Any other questions on that point?
Good.
Okay.
Okay. Question.
Go ahead, Joe.
Go ahead, no, if you got.
I was just going to say, I think, Madam Chair, you had a third question, which was if it was a case that's being continued. So there hasn't been a compliance order entered yet. There hasn't been an appeal because the case has been moved to another code enforcement board date.
Right.
Are you allowed to ask, what is the extent of status updates you could request on that?
I mean, by status, all I want to know is where's the case, not what is happening on the ground with the alleged violation. All I want to know is where's the case.
And again,
and that's a distinction.
And my stance is again, not asking any, what are the status of, because any status of the facts, status of the facts, or any facts of the case.
Right.
But status of and that's what I would actually, my recommendation to even staff would be, say, well, is it going to come back to you in the next few months? That's it. Limit it to that, because what I don't want is any outside information.
Understand.
To get to you when you potentially could rule on it.
Right. And that's a sunshine issue. I understand.
Joe, did you have another question?
Understand the limitations as a board member. if you observe an obvious code violation, as a board member, what are your options? I mean, you can act as a private citizen, or you can ignore it, or what?
I will say a couple of things, and I'm sure Dan will chime in with a few things extra. One, just like city council, there is, once you are a board member, for purposes of statutes, there is no distinction between board member and private citizen. You're a member of the code enforcement board. Code enforcement board members are not permitted to initiate code cases. So you could not, it's my understanding that you
can't
could
call in
not
a
submit a
complaint.
code complaint because you are a sitting member on the code enforcement board.
I think I asked that question once before and you answered correctly, but you also mentioned, I can't, but my husband can.
If they're not a code enforcement board member, then they can submit the complaint in compliance with the city's
As a
complaint
private
procedures as a private citizen submitting. Now, as a reminder, just for the record, that code complaints cannot be submitted anonymously. That's a state statute violation. They do have to provide a name and contact information to submit a code complaint. But yeah, as a board member, you cannot submit a code complaint that would potentially come before you.
So can you ask if there, other than, since it would be a matter of public record, or if there was a code violation, it would be on the city website, right? So if you notice something, you can either look it up, or can you ask, is there anything pending on any given address, or is that crossing the line?
One of the things that is going to be talked about later in this presentation is ex parte communication. And one of the things about ex parte communication is it's not just someone talking to you about a case, but it's actually something if you observe it. And so I think we've even discussed this about before. I will change one thing. If you see it, if you can't initiate a case. You can make complaints for staff to initiate case. However, that is an ex parte. If you observe something, that is an ex parte communication which has to be disclosed. And that's the distinction I'll make from that. Is that if you see something and to be investigated, I'm fine with that going to staff to investigate to see whether or not they bring a case. But again, as Jen said, first, it's not going to be an anonymous. It's not going to be an anonymous complaint. But second, that is considered an ex parte communication because you observed it. You received outside information, even by seeing it, that has to be disclosed on the record, and that doesn't immediately disqualify you from ruling on something, but it is going to ask more questions. And the two main questions. This goes to what's called site visits, because I deal with a lot of beach communities where literally you have one drag strip, and your road, it's one main road, so you usually drive by either violations or whatnot, so it's impossible for you not to see it. But the questions are, can you be fair and impartial? And because you have seen this information, that is the question. But you also have to provide the opportunity. That's what I'll ask you. But if the respondent's here and wants to ask you questions about what you saw, and that it opens up those lines of questioning, because it goes specifically to due process. So even if you were to do it, if your spouse were to do it, if you were to ask another person to do it, or someone else did it, if you have that essentially visual information, that is ex parte communication. That needs to be disclosed on the record. And then the second part was, well, let me look up pending cases. Don't look up pending cases. Don't. And here's why. It's because, again, it goes to, you can be a witness. You as a board, you can be a witness or you can be a judge. You can't be both. Dave Person in my firm, that was all we always told boards. You live in a bubble of the information that is presented to you. Staff provides you with the information to make your rulings. You cannot do your own research on cases. It's what is provided to you that you have to make your rulings.
I know this was further on down the docket because I was going to raise the same question. that my colleague just did, because if I understand it correctly, there's a state law and a city ordinance forbidding that. Is that correct?
Forbidding what?
Forbidding a board member from filing a complaint or offering a complaint.
Yes, under chapters 162 of state statute, code enforcement board members are not permitted to initiate code enforcement cases. It must be initiated by a code compliance officer, and chapter 9A of the city code of ordinances reflects that language. From
Yeah, you will
chapter
not take an
162.
anonymous complaint, is that correct?
Well,
Correct. That's also under state statute and also reflected.
Well, that's
in
a
city.
catch-22.
Well, what you have to understand, what we mean by initiate is staff was who is bringing like a notice of violation? You as the board can't bring a notice of violation, a notice of hearing, and saying you can't say, I saw this violation, I'm bringing this in front of the board. That's what city staff does. They are the ones who are issuing the notice of violation that someone has potentially violated the city code. You as the board make a ruling on whether or not there was a violation. So, Chair Higgins, you have an amazing chair, but Ms. Higgins can't write up a notice of a violation and then have it served on a property owner saying you have violated the code. That's what that means. You cannot initiate a code.
But what we can do, and please help me, correct me if I'm wrong, is if we observe something, we can notify staff, staff investigates, maybe brings a case. If they do bring a case before us, then we are required to disclose the fact that we contacted staff about this.
Correct.
And that would resolve the issues.
Yes, and whether or not you are ruling on it.
Right, and
That's
then,
a question. That's for that specific
right,
case.
and let's assume, just for the purposes of argument, that it's your next door neighbor and you've had an ongoing dispute about this issue, then you might have to recuse yourself because you have a position.
Yes. I do know attorneys who take different stances. The only reason you can recuse yourself on cases for voting conflicts. However, I don't read the statute that way. And quite frankly, for a due process issue, if it's clear that you cannot, if you can't be fair and impartial, I don't want you ruling on it.
Right. I mean, the rule. I mean, in my view, is if your neighbor wouldn't want you ruling on it, if they feel like you've got a dog in the fight, then you shouldn't be ruling on it.
And the thing about it, especially since you cannot do anonymous complaints,
they'll find out.
Your name will be as who
On the
issued,
record.
who called out to city staff. Their name will be there. So it is incumbent upon you to acknowledge that yes, I made this complaint.
Right.
Now you've confused me a
I'm
bit.
sorry.
No, that's fine, because I need a clarification on this. And Mr. Faulkner, he and I became acquainted due to my neighbor having a violation when my seawall collapsed. They couldn't repair the seawall because of a derelict boat that he had floating over on my property. So I filed a complaint with the city because he refused to move that boat so they could work on my seawall. I was not on the board at that time. But now, if I had been on the board, what you're saying is I could not have filed a complaint against him?
Well, you didn't file a complaint. You advised city staff that there was a
Right.
possible complaint. City staff was the one who did the notice of violation, who did an investigation into it, and then they were the ones who brought it to the board for.
So had I been on the
adjudication.
board at the time it happened, I would have been in my rights to notify the city of this derelict boat.
Yes. Now, whether or not the city staff did something about actually open investigation, that's up to city staff. So the idea is you are separating the powers. You are, again, you are witnesses or you are your judge. But I saw this and I'm saying you're in violation. That's a violation. That's due process right there. It's not, you can't, so you don't have two roles. Everyone has one role.
And in that instant, and that was one of the reasons I asked the city attorney prior to recuse yourself, if I was on the board, would I have to recuse myself when that case came before the board?
Not necessarily, but again, like I said, there was going to be questions because it's ex parte communication. You have made observations, and there are going to be questions. You'll be questioned most likely by myself and by the respondent if they're here about whether or not you can be fair and impartial in that. So it's as opposed to say special, as opposed to if you have a voting conflict, like if you're going to have a special gain or loss by a case where you have to recuse yourself from a case, and you have to acknowledge it. We're going to have some questions about whether or not you can be fair and impartial in a matter.
Thank you. So this is continuing from the chair's comments and about the website. So for a long period of time, there's been a frustration on the board about what she was talking about. Where do things stand? You know, we make decisions, things happen, and they just sort of go away. And so finally, several months ago, Ashley brought up the website, and they said, oh, there's a website. Here's this information. And y'all gave us training on how to navigate the city's website to find all of these statuses. So now we're not to do that anymore.
I'm not saying that at all. What I'm saying is, if you want information that where you're not going to be ruling on it, what I'm concerned about, what my concern is, if a case that you're going to be ruling on, but you haven't heard the case or it's still open, and then you go out and start essentially seeing information that wasn't provided to you directly from city staff. You're doing your own research. At that point, you have gone beyond the adjudication role, and you are now a witness because you have gotten extra information that wasn't provided on you.
So if you wanted to research something like long-standing pieces of property that, you know, you just kind of go, when is that ever going to? And you go and you start researching that, and then it comes back up. You have to then say, I have done research and have learned that there's a 10-year history of violations here or something.
I mean, if it's going to
affect your decision, you need to disclose it.
It's safer. There's no such thing as too much due process. I'll put it to you that way. It's never a bad thing to say.
By the way, I looked it up.
By the way, yeah.
It's never a bad thing to say that.
I Googled this. And
no, well, please don't Google things. I wince I have been in board meetings similar to this where people have pulled out their own personal iPads and started pulling up maps and whatnot, and I wince at it every time because you shouldn't be doing that. But my point, the safest thing for you to do, you have a very unique power as a citizen and resident of the city, in that you have a say in adjudication of its code violations. But with that comes responsibility. And I understand many people are on the board. You're on this board because you want to be proactive and you don't shy away from things. That is how all my boards are, and I appreciate that. But at the same time, one of the things that especially I'm always concerned about is it's easier to not do extra work, because one of the concerns I always have is people who do the extra work potentially create potholes down the line that they don't even realize that they can create. And am I overly, myself as an attorney, am I overly protective about this? Yes. But that's also because I have seen the craziest things happen in many different cases that no one ever really thought of that could happen. So the easiest way is don't do your own research. City staff will provide you all the information that they need for you to make your decisions on things. Let them give that to you. Because the easiest thing in the world to do is, if there's a question of ex parte, if you say, I've received no information or I haven't done anything, guess what? It's a done deal. No more questions about it. It's over at that point, and we can go forward with no problems. But if we have to get into rounds of, well, I looked up like the 10-year past history of this case, or I know X and Y and Z, records become messy, cases become messy, and it just opens up cans of worms that it's not really, none of us want to really even deal with. And that's my point of, I want to be protective of this board, because last thing I want is for you to spend time and effort on matters and cases that you care about, and then it goes up and then it gets overturned, because especially with due process. Due process is the lowest hanging fruit known to man.
Sure.
And it is the quickest way to get a case kicked back to you that you have to do all over again.
Oh, yeah.
And so, am I being overly protective? Yes. Am I trying to be stringent on you? Yes.
Yes.
But I'm trying to help you I'm trying to make your life a little bit easier. And that's my main goal. So I'm sorry I went on way longer than I
No, that's okay, and that's fine, thank you.
Jen, I don't want to take up any more time.
No, and we absolutely appreciate these questions. A lot of when we were reworking these slides was to answer the things that I know you all have on your mind, and so the Q&A is perfectly fine. If at the end of the day everybody walks away from this a little bit more clear about what you are and are not supposed to do, that's ultimately the goal of this training. So, okay. Now we are going to get into the public hearing procedures, and a lot of what we just talked about will be encompassed in some of these slides coming up. So the city has basically two types of quasi-judicial hearings: land use and permitting requests, which are more the purview of things like the canal advisory committees, the planning and zoning board, and we have boards that deal with enforcement proceedings, like you all, the code enforcement board. So the city has established quasi-judicial hearing procedures that apply to both types, but there is a distinction primarily in the participation of the public with those meetings, so we'll talk about that in a little bit as well. However, regardless of what type of hearing it is important to note that fairness, impartiality, and due process must be afforded to all parties in a quasi-judicial hearing, and that your decisions are to be based on the application of reliable facts to pre-established criteria. That criteria being obviously what defines a violation under the Code of Ordinances and whether the evidence presented to you measures up to that criteria. So just kind of to go briefly through who's who in the hearing, you all, the board members, you function like the judges. You hear testimony from sworn witnesses, you review the evidence, and you make your decisions based on the presentation of that evidence and testimony measured against what is set forth in the Code of Ordinances. City staff, they function kind of like the plaintiff, only in the sense that they are the ones initiating the complaint to come before the board. They bear the burden of providing evidence that the violation or that the non-compliance they are alleging does in fact exist based on the parameters identified in the Code of Ordinances. And then the respondent, they function like a defendant in the sense that they are the ones who respond to the complaint. And it is their burden to submit evidence and testimony that mitigates or invalidates the alleged violations. And then you can have witnesses. The important thing that we want to point out about witnesses is that these are people that must be called by the city or the respondent. They must be disclosed in advance, and the testimony that they provide must be relevant to the allegations contained in the notice of violation. And that's different from somebody who's just sitting in the back of the room who says, I have something I'd like to say about this case. That person does not count as a witness. And in the context of an enforcement quasi-judicial hearing, that person will not be given an opportunity to speak. Witnesses have to be disclosed by the parties. They are called specifically by either the respondent or the city, and their testimony has to be relevant to the allegations in the notice of violation. So I want to make that distinction clear. They may be members of the public, but it's different than allowing public comment, which under our city judicial hearing procedures for enforcement proceedings, we do not allow public comment for this reason. Then you have the board attorney. In our case, it's Mr. Lewis, who serves as the legal advisor to the board and answers all of your questions about application of the criteria, how to consider the facts and evidence that is presented to you, and provides you guidance on the criteria for your findings and deliberations. Then you'll also have the prosecutor, who is the city attorney. In this case, I believe you all met Mr. Leskovich. He's the interim city attorney. So he represents the city. And in a code enforcement board hearing, the city attorney and the board attorney cannot be the prosecutor, and the board attorney cannot be the same person. So that's why we have two individuals here, because their responsibilities are a little bit different. Mr. Leskovich, as the interim city attorney, is is basically representing the city, whereas the board attorney is providing guidance to the board about how they apply the facts and the parameters of what's allowed for their deliberation and ruling.
A question? Sure. Go ahead, you go first and then I have a question.
The respondent is allowed to call witnesses.
Yes.
We've had that happen before. I'm a little confused. Does the respondent have to notify the city ahead of time that they're going to call witnesses?
Yes, they are supposed to disclose the witness, just like in a regular trial where they exchange witness lists, the same thing applies here. The city is supposed to provide notice of witnesses that they'll call on behalf of the city. They provide that information to the respondent in advance, and if the respondent wants to call witnesses, they're supposed to provide that information to the city in advance of the hearing.
Does the respondent know that?
I believe that information is communicated to the respondent. I believe it's contained in the language in either the notice of violation or the notice of hearing. But we can double check that.
Yeah, because we've had cases where a respondent has showed up with several people.
Sure.
And they've all stood up to talk for the respondent, and I'm a little unclear whether or not you all received notice of that ahead of time.
We'll have city staff look into that, and if they're able to provide an answer during the course of this training, which it looks like Rachel, the zoning official, has a comment on that front. Thanks.
Hi there, Rachel Berry, zoning official. And so looking at one of our notice of hearings and affidavit of violation, it does specifically state that if they elect to be represented by legal counsel, they must notify us. I don't see anything specific to witnesses, so we can get these.
Yeah, that needs to be changed then, obviously.
Yeah, and the city can waive that requirement too. I mean, if they come with if they come with 3 witnesses, let's say, yeah, you're supposed to tell them, but the witnesses are here. The city can waive that requirement, maybe take a break and talk to the witnesses or whatever, in the interest of moving the case forward.
Sure.
That kind of
And
thing.
I also know that at least in the few instances where I have attended a code board meeting where witnesses testified on behalf of the respondent, it seems to be that the primary issue was not the presence of witnesses and advance notice of witnesses, it was the scope of the testimony being not relevant to the allegations contained in the notice of violation.
Right, okay. I have a question and then a comment. The question my question says, city attorney representing the city conducts direct examination of city witnesses. Our practice has been that the city's witness, that is the code enforcement staff, introduces the case and then produces evidence. Do you want to change that practice and have the city attorney do questioning?
We can have Mr. Lewis respond to that. I know I've seen where, like, for a appeal of citation hearing, the city attorney has done the questioning of, the issuing officer and the respondent, things like that.
Yeah, I mean, in many cases, first of all, there's no respondent. And, I mean, we always have had the respondent have the opportunity to
Sure. So I'll let Mr. Lewis provide some guidance on that.
Mr. Lewis.
So that's in the way even the city code is it's permissive. It's not a requirement. It's really, and that's ultimately how the city wants to run their own case. And as someone, again, I do code enforcement both as a special magistrate and as a board attorney and as a city and town attorney as well. So every city kind of does it slightly differently, however they want to kind of go about it. But that specific question, it's a good question, but it's best to kind of leave that however the city wants to run their case is my general rule on that.
I mean, from a personal perspective, I have no objection to the current practice. I think it's efficient and I think it makes sense.
And I will tell you, the current practice is not uncommon in other municipalities as well. Same with the respondent calling witnesses. They are supposed to give us notice, but I agree it's generally waived with the city. If the city were, the proper procedure would be to, if the city wanted to, if they didn't get any notice and they wanted to, it would be to ask for continuance.
Right.
But it may, depending on what the allegations are, depending on the case, it's probably in our general practice, it's probably best to just kind of go forward with the case. But ultimately that's the city's determination if they want to ask for continuance or if they just want to go forward. It's depending on the notice. was brought before us, that would be, I would advise you all, is the city can ask for continuance if they want, or they can choose to go forward. They're putting on their case.
Okay, and then my comment is, from time to time, we have cases where there's an alleged violation, and then there's the neighbors who are all here, who want to put in their 2 cents, or they want to hear, or they want to see the case. If they want to see the case, that's fine, but if they want to put in their 2 cents, then there's the issue, of course, of them being witnesses, which I understand. In appropriate cases, it may be helpful for the city staff or the city attorney to speak with some of the neighbors and bring in that point of view, either directly or indirectly, to bring in front of the board. So, for example, let's say you have 6 neighbors who say, this violation has been ongoing. The guy's been, been a real problem with this, and he's not doing it, and whatever. Maybe it might be helpful if the city attorney brought in one of the neighbors, or incorporated that in the staff comment that the neighbors have been complaining about this, or whatever. Just a comment.
I will say just on that point that if staff were to incorporate that information into their findings of fact, it would be more defensible to have them called as a witness to provide that information firsthand.
Okay, whatever you decide to do.
And again, I think at least what I've seen in the past is that the situation that comes up most often is that testimony either does not directly relate to the allegations contained in the notice, and then the board has to be advised of what they're allowed to consider and what not to consider. Whereas it would ultimately, and I believe Dan would agree with me here, it would be cleaner to not have that person testify if the information they're going to provide is just, my neighbor is a jerk, and I don't, he does all of these things.
And that's a matter of judgment, and
Sure.
I mean, that's a way of basically standing off the neighbors by saying that's really not the issue. The issue is, did this happen? How long has it happened? What's been the response
Right.
in terms of the...
Yeah, and I agree that would be staff discretion, and I know that code enforcement staff does regularly speak with neighbors or people who live across the street, because either they're, trying to get information on the respondent, or the violation has been alleged by a neighbor or somebody. So it would be their discretion based on those conversations if that's someone that staff wants to call as a witness. But if they were to incorporate any of that sentiment in their findings of fact, I think it would be better to just have them as a witness.
Okay.
And then either staff or the prosecutor could question that person on behalf of the city to provide that testimony.
Okay.
And because this is a big sticking point with me, but it's a great question, because this comes up with every code enforcement is.
Sure.
Again, and the way I always put it together is when you either dramatized or you watch a real court trial go on, you never see public comments. There's never a public comment section, and that's what I always want to relate it to, because this is still, while it's quasi, it's still judicial. The best, if there is a lot of case law on this, and I've heard from every majority of the practicing city, small government, and special district attorneys that don't allow just people to speak in that. However, if the city wants to call them as a witness, that is completely the city's right to run their case as they want. And that's the way I put it, is if the city wants to talk to the neighbors and call them as witnesses because it has relevant information, totally their call, and that's how they run their case. If the question, say at a hearing, we had 6 neighbors up and the city didn't want to call anybody, and they said, I want to speak, but the city's not calling them, that is a no, because even if that respondent's not here, they could still appeal this, and that is always the thing to remember. So that's why we put in a note, that's why we put in the not guilty, that's why we still run through the case.
Right, and in my view,
Yeah.
if let's say we have the 6 neighbors, and the 6 neighbors have talked to the staff, and the staff chooses not to call them, that's the staff's discretion,
Yep.
and that says something right there, and I can say that to the neighbors. You've made your point to the staff, it's the city's responsibility to bring the case. You've done your part.
100% agree.
Slight little follow-up. So on the other side, respondent notifies he or she is going to have witnesses. brings forward 5 witnesses who start to get up and have nothing to say that is relevant, is that when you as our attorney or the city attorney steps in and or the chair can limit their comments?
I would go towards the chair. But here's also my point on that. When a respondent calls a witness, my general belief is you give them more leeway.
Sure.
Only because
They're not lawyers.
They're not lawyers, and also you never lowest hanging fruit, due process. If they said you don't want them you don't want them getting an attorney saying, I was going to have a witness and they had all this information and I got cut off and that's the other thing. It's what we're really protecting against. If the respondent's calling witnesses to help them, that's providing them due process. If we're having just neighbors say this person's a jerk and I don't like them, that is potentially cutting against due process because you could be ruling on the animus of the community, it's called. So I always take the rule as, please, and warn them, and it could be the city's attorney saying that we're veering off. It could be me to acknowledging them, but ultimately, if we got to readjust it back to that, that's fine. But I always say more leeway to the respondent, especially if they call witnesses, because you can never have too much due process.
Okay, and yeah, our chair has done that in the past, but my question would be after like 3 or 4 minutes, if she can't rein it in, then it might be
Then I
incumbent.
might need help.
Yeah, and I get that, and that's fine too. And that honestly, I would pipe up.
Okay.
Yeah, because what my concern was, it would be I would pipe up saying at this point, as further backing to the chair, so like we need to get back on track.
Right.
This is relevant. We're going outside the scope of the violation.
Good.
That's why we're glad you're here. Thank you.
Thank you.
And I will make one follow-up comment, which is that, yes, respondents are allowed to call witnesses under due process as well. The city attorney or the prosecutor is allowed to cross-examine those witnesses, and that would also be an opportunity for them to frame the testimony and to provide information, to ask questions to determine whether or not that testimony is relevant to the allegation. So that is also under due process an opportunity for the city attorney to help get that back on track as well.
Thank you. Good point.
Mm-hmm. Okay, so the next slide just talks about basically the parameters for the rules of evidence, what you all are allowed to consider. So it must be competent and substantial evidence that is presented at the hearing. That competent substantial evidence is basically just defined as that a reasonable mind would accept is adequate to support the conclusions reached. Hearsay evidence, it may be used for the purposes of supplementing or explaining other evidence, but it cannot be the basis of your decision. So we just wanted to make that distinction, and that includes things like, for example, if city staff came up and said, well, that wouldn't be because they were participants in that conversation. But if you're talking about information that was provided via a third party and you are not testifying to firsthand knowledge or information, then that's hearsay evidence because it's coming through another person. Again, it can be used to support or explain other evidence, but you can't use that as the basis of your decision. And obviously, if it's not presented during the hearing, that's an issue as well. We've talked a lot about ex parte communication already, so just to reiterate, as Mr. Lewis said, that is basically information that is gained outside the context of the hearing. It is permissible, but it does have to be disclosed prior to the board's action, and then it does open up questions as to whether or not that board member is able to continue being fair and impartial in their consideration and ruling on that matter. And this is, as Mr. Lewis stated, an opportunity where board members they have the option to recuse themselves from deliberation and ruling if they feel that they cannot be fair or impartial, or if they want to protect the due process and appearance of fairness and impartiality in the case. So it is an optional recusal at that point, which is different than the conflict of interest, which is a mandatory recusal, which we'll talk about in a few slides. And then just a little bit more on due process. So this is basically the bullets at the bottom of this slide show kind of the steps that a code case goes through to protect due process. So they get a courtesy notice from city staff. If it's not corrected, then they get a notice of violation, a notice of hearing, which is when it comes to you all enter the compliance order, which again gives them a notice of what they need to do in order to get things corrected before it's escalated to the next step, which would be the penalty hearing and an order imposing penalty. So I know that there is frustration sometimes from the board and from the community about the amount of time that code compliance takes, but in the same vein of it's better to set 100 guilty people free than put one innocent person in jail. It is better to ensure that everybody is afforded the due process under our code of ordinances, and sometimes that does come at the expense of speed. So, and then this is just we can get you all some printouts of this. This is a really great flow chart that the code staff put together for their Citizen Summit presentation that just shows kind of all the different ways that that a code case can go from initial investigation all the way through the enforcement and penalty phase. So it's a really great graphic to help understand what steps are happening before it ever comes before you, helps you understand your piece in this overall flow chart. And it helps you understand that timeline of due process and that order of operations and all the different opportunities that residents get to be in compliance if there is an investigation.
That's a great flow chart.
It
Whoever
really
did that,
is fantastic.
It really is fabulous. And that's included in that little packet,
Oh,
which is
good.
terrific.
Fantastic.
Yeah.
Maybe we'll get a great big poster of it printed and we'll just leave it at the back of the room during code board meetings for all to see.
You might want to hand them out or whatever. I think they're really helpful.
Yeah.
Send it out with your letter.
Yes. Well, so we'll start including that with the notices of
You
violation.
are
We'll
here.
just send, yes. That's an excellent idea.
Here come all.
All right, so now we're going to go briefly through the conduct of hearing, basically the order of operations, and we'll talk about the most common ones that come before you. So our hearing procedure is set forth in our Code of Ordinances, Chapter 9A. It's in accordance with state statutes under Chapter 162. You all hear a multitude of things: first-time violations, repeat violations, penalty hearings, fine reduction requests, sometimes non-moving parking ticket citation appeals, things like that. So all of those, have a few distinctions. We'll talk about the most common ones, but they're all considered quasi-judicial hearings. And the first thing that happens, regardless of what type it is that the board recorder or the city staff designee has to swear in everybody who testifies or speaks into the microphone during the context of a public hearing should be sworn. Okay. So for first-time violations, so we've made kind of some of our own little flow charts. You do need to have entry of a plea. As you all know, if the respondent's not here, it's a plea of not guilty entered on their behalf. Then you proceed to the city staff's presentation where they give their findings of facts, which can include photographs, information about the notice requirements having been met, testimony about the current state of compliance, any re-inspections, and that's the opportunity for board members to ask questions. And the respondent does, if they are present, they do have an opportunity to question city staff on the facts that they've presented at that point. So once you have your findings of facts, you all proceed to your prima facie determination for a first-time violation. That basically just means that the evidence that the staff presented on its face supports the allegation of those violations. Essentially that the criteria set forth for that violation to exist in the code, city staff has checked all the boxes for that to be heard by the board. And that must be done by motion ideally before you proceed to the rest of your deliberation and before you proceed to any testimony by the respondent, which comes next if you do find a prima facie. Okay. So then if the respondent is present, they have an opportunity to present their mitigating evidence. can be, you know, these are just some examples of things that they might be presenting. The board members are allowed to ask questions of the respondents, and again, as I mentioned, that's an opportunity for the prosecutor or city staff to cross-examine the respondent on the information that they've presented, include respondent and their witnesses. Then, after you've heard from both sides, you would have your deliberation, where you review all the evidence and testimony that was presented. You can seek advice from the board attorney about how to consider any of that information, how to apply the criteria under the code, and just a reminder that your question should focus on the scope of the evidence that was presented at the hearing. And then you come to your ruling. So this is where you determine whether or not the respondent was guilty of the violations that were alleged by the city. If you do find the respondent guilty, then you'll enter a compliance order that typically includes the cease and desist for future violations, a time frame for compliance, assessment of case costs in the time frame, and then the notice to the party that there may be a fine imposed for non-compliance. Okay. Any questions on the process for first-time violations? Excellent. All right, then sometimes you have repeat violations, which are a little bit of a mashup between the process for a first-time violation hearing and a penalty hearing. So repeat violations are kind of a combo of both, and we'll talk about why. So basically, if you have a repeat violation, you still go through essentially the same process as the first-time violation. You still have to establish a prima facie finding for the allegations of repeat violation. You still need to call for a plea if the respondent is present, or enter not guilty on their behalf. They are still allowed to provide testimony about specifically the repeat violation and the existence of that.
By repeat violation, do you mean a case where the violation is non-corrected, continues to be non-corrected, or somebody who's had a prior incident?
Somebody who has had a prior, like for example, if you had a case that came before you for
mowing grass,
tall grass and weeds, right? And then that, you know, it was either corrected or not corrected, but then they were cited again for tall grass and weeds sometime within a 5-year period from the initial case, then that's considered a repeat violation. Okay. And really the only difference between repeat violations and the first-time violations is that under the code, repeat violations, the board is not required and city staff is not required to provide a reasonable time for correction before a fine is imposed. Whereas if you think about when you do a first-time violation in your initial compliance order, you don't impose a fine at that point. You say, if you don't comply within X number of days, you may be subject to a fine. Okay. Whereas with repeat violations, you still have the same burden in terms of the evidence and testimony, but if you do find that a repeat violation exists, you are allowed to impose a fine in the same hearing.
Immediately.
Because they're in violation of the cease and desist that you gave previously.
Yes, they are in violation of that element of the compliance order, and there is specific language in the ordinance that allows for that sort of expedited process because of a repeat violation. Okay. So you have there a couple different places in the code, 9A-6 and a couple sections in 9A-8 that talk about what the board is empowered to do for repeat violations. So because you are allowed to impose a fine if you do find that a repeat violation exists, there are a couple of things that you should consider. The gravity of the violation, actions taken by the respondent to correct the violation, and any previous violations committed by that respondent. And best practice would be essentially, and I really appreciate, Madam Chair, what you've been doing, which is to ask people board members making the motion to describe sort of their rationale behind either the time frame or the amount of the fine imposed. And best practice is to do that so that you have that on the record. For the imposition of fine, the basis should be based on one of these 3 criteria or a combination thereof.
And the board has been, is I think, really good about trying to be relatively uniform.
Yes, because that is also a consideration.
Right.
Under due processes, you know, it is concerning if you are imposing a significantly greater fine for the same violation between respondents unless those three factors come into play and provide the rational basis for that. Okay. Any questions on repeat violations? All right. So then penalty hearings. This is what you, Madam Chair, were asking about, which is if you have issued a compliance order, the respondent does not come into compliance, a reinspection is done, and the property is still found to be in non-compliance with that original order, that original citation, then they can come before the board for a penalty hearing. And because this is based on an original citation and an original compliance order, you do not need a prima facie finding or entry of a plea. Do we see the distinction between why you don't need it here and why you do need it for a repeat violation?
And I'm assuming the board keeps track of the orders that have been issued in terms of re-inspections and
The
making
city staff
sure-
does, yes.
Yes.
Yes. Yes, when you enter your compliance order, city staff makes note of all of those timeframes and deadlines and then follows up on that. Because if they do want to bring that before you for a penalty hearing, they have to provide evidence that there was non-compliance with that initial order. Okay. So under a penalty hearing, the testimony and the evidence is a little bit more limited. It is not an opportunity to re-adjudicate or rehear evidence about the initial. You guys already found that there was a violation and had an order saying you have this amount of time to comply. So we're not going to talk about the circumstances under which that violation existed again. All you're going to talk about in a penalty hearing is compliance with the order. What steps were taken to comply, what steps were not taken to comply. We're not reopening the violation for deliberation. So I want to make sure that that's clear. Okay. So then after you have the staff presentation on the non-compliance with the initial order, the respondent does have an opportunity to present evidence as to how they have potentially complied with that or what kept them from complying with that initial order. Again, it's not an opportunity to re-adjudicate the violation. It is simply going to be limited to compliance with the order and mitigating and aggravating factors under that. Okay. So then once the respondent, if they're present, provides that information, then you proceed to your deliberation and ruling. If you do determine there was a violation of the compliance order, then you can go ahead and impose fines up to $250 a day for a first time, up to $500 a day for a repeat violation for the duration of non-compliance, plus allowable case costs. And just like we saw with the repeat violation, anytime you're imposing a fine, whether it's a repeat violation or under a penalty hearing, oops. It just went to sleep. That's weird. Brad?
Well, maybe it's telling us.
Sorry, apparently the computer is over the board training. No, I didn't.
She didn't touch it.
I did nothing.
Battery dead.
Give them all. That should keep them on. There's a lot.
Just all of a sudden kind of decided to go to sleep.
It's not getting this open now. Let's give me a little bit of this.
Sorry, does anybody need a break while we're
42 total.
getting
Yeah, I would
the
love it.
technical
Thank you.
difficulties? Would you just call for a recess?
Oh, okay. We're in recess.
Have you called the meeting back to order?
I did.
Okay, excellent. Sorry about that. All right, so I believe, yes, we were on just this last slide about penalty hearings, and I was reiterating the factors that are acceptable for consideration under imposition of the fine. And best practice, again, is really to vocalize which of those factors it is that you're using as the basis, or which combination you're using as the basis for the imposition of the fine. That's excellent information to capture on the record. All right, then we're going to talk briefly about requests for fine reduction, which sometimes come before this board. Again, these are ones where it is tied to an original violation, an original compliance order, so you do not need a plea of entry or a prima facie finding. This is where you have gone through the penalty hearing, imposed a fine, the respondent has come into compliance and remains in compliance, and they are asking the board, hey, because I've done all that good stuff, would you please consider reducing the fines that you imposed? That request must be submitted to city staff in writing. Then the hearing for the fine reduction request is limited to the circumstances that they say are relevant to the fine reduction. So again, you're not re-adjudicating the violation, you are not hearing testimony about whether the initial penalty imposed was fair, unfair, reasonable, unreasonable. All you are hearing from during the context of that hearing is, this is why I'm asking for the fine to be reduced, and city staff's information as to whether or not the respondent has met the requirements to be eligible for a fine reduction request.
They have to be in full compliance before they're eligible.
Yes, they do. So respondent must be in full compliance with all board orders from the date of the request, from the date that they submit their fine reduction request, all the way through the date that that request is heard by the board. That's the requirement. And that's what city staff would be providing information on. Generally speaking, if it makes it onto the agenda, then that is the assumption, but staff will be providing that information because they go out and they do inspections usually the day before a code board meeting, and they have to make sure that that property is remained in compliance all the way through the date of the hearing. So you may hear information, as to whether or not that property is or is not in compliance as of the date of the hearing. That's something staff would present, and then the respondent has an opportunity to present their information as to whether or not they have remained in compliance and the basis for their reduction request. Okay. So then once you get to your ruling under this type of a hearing, if you do approve a fine reduction, your order should contain the amount of the reduction, how much you're taking off, what the outstanding fine is, so how much they actually need to pay, and then a time frame to submit that payment to city staff.
Can that be appealed? If
Say
the
again?
board decided not to give them a fine reduction, can they appeal that?
It's still a decision of the board, so I believe that would be appealable.
Not
But-
not the fine reduction.
Not the fine reduction. Okay, so the only board orders that could be appealed are a compliance order and an order imposing penalty?
Correct.
Okay,
Really?
interesting. Thank you for that clarification. All right, so there were a couple of things that we just wanted to go over with the board in terms of conduct of hearing. This typically comes up under the first-time violations, but it could be applicable to first-time, repeats, penalties, any of that. And this is regarding the allowances under the code for when there is a violation that poses a threat to public health, safety, and welfare, or is an irreparable or irreversible violation. Those can be treated slightly differently under the code. And the first thing that we want to remind the board is that just like every other alleged violation, that information about whether that violation fits those criteria must come from a code compliance officer. If they do not include evidence or testimony of that in their findings of fact and in the hearing before the board, then the board really is not empowered to ask hypothetical questions about whether it is a threat to public safety or welfare, whether it is an irreparable or irreversible violation. Those are determinations made by code compliance staff and presented to you, and if they're presented by city staff during the hearing, then you are absolutely allowed to consider to consider that in your, or, you know, as you make your determination for a compliance order or an order imposing penalty.
So in the past, we've had situations where board members have asked, is there access to the pool because of the damage? Because they're worried about a young child being able to fall into a pool because of damage to either a screen or a
Sure.
fence.
Sure.
So
So that,
are you indicating to us that we shouldn't be asking that question?
I think, and I think Dan would bear me out on this, I would caution against raising those questions if staff have not said, we also, you know, we have considered the threat to public safety and we find that one does exist because of the location of the pool enclosure or the amount of damage to the pool enclosure, those type of things. And I think it goes back to that, you know, that due process concern, and also it complicates the basis for your decision. If you are raising those types of questions, then there could be an argument made that you are using that as a factor in your order when that evidence has not been presented to you by city staff, and that could be a potential basis for appealing the order.
Again, it goes back to your role as an adjudicator and not as an advocate or as a witness. Because if the city staff is not telling you that this is and this is one of the most significant powers that you as a board can actually put in place, because you are actually saying, not only is there a violation, but now we can go onto the property and fix the violation. It's going beyond even just imposing fines because it's not being corrected. We're saying the city is going to go do it on our own because you haven't corrected it, because we find that there's a threat. But as with anything else, that information has to be provided to you, because it goes back to the initiating the case.
They need to understand they have that allegation.
Yes, and that needs to be before it. If someone comes here and says, like, if they come here for a hearing and city staff says nothing, and also just how it looks on the transcript or recording, if city staff says nothing about a violation of serious threat to public health or safety or welfare, and there's no real evidence to support that, then there's not really but there's nothing that's been discussed. It's, say, brought up in deliberation at first blush. At that point, evidence has been taken, it's done, and it's closed, but there's no real supporting factors for that. It is the board just making that determination with no real underlying foundation for it.
But instances where those questions have come up, there's been pictures of a facility where it appears that exists. So those pictures have been placed before us as evidence.
Appears that it exists. Think of how that was just said. It's not the city telling you that that this violation presents a serious threat to public health, safety, and welfare. It's saying that this could potentially be happening.
But that's why the questions would be asked.
But the city has to tell you that. It's going beyond your scope of adjudication, and at this point, I'm not adjudicating something. I'm making a determination that's on evidence that's not specifically before me. It's the city again. It's for the most significant power, one of the two most significant powers that one of these orders carries, to go onto the property. You would need the support. What you also don't want is reading a transcript where it seems like the city was backed into it because of board questions. The city needs to be presenting that evidence to you that this was a violation that presents a significant threat.
Okay. However, we can split the baby from the standpoint of, let's say we have a pool enclosure that the screens have been ripped out. We can, because of the potential threat, we can issue an order which requires more immediate compliance. We can, if the time came for a fine, we could have a more significant fine based on not the fact that there is a serious threat, but that this is a situation which is not just a cosmetic issue, but is a potential threat.
Exactly. That is exactly the point that I would want to be considered. I'm not saying don't ask the questions. What I'm saying is there's a distinction in the authority that's put into your orders. When we're saying that there is a violation that presents a threat to public health, safety, and welfare, that is in indicating that if you don't correct in this time, the city's going to do it for you and charge it. However, if this is an issue where, just as Chair Higgins pointed out, you know what, this potentially could present a problem or a danger. What if there's some children? Don't give them 30 days. Give them 10. Give them 5 days. Or that is the better use of those questions, right? If the city is not telling you that this is presenting a threat and we're seeking, intervention, that's exactly what you do. You give them less time to comply. And that was even discussed when it's brought up, like, why are you giving 60 days? Why are you giving 30 days? Well, that is the perfect time and the perfect rationale. Like, well, I'm concerned that this could cause a problem for, children or whatnot. So I don't want to give them 30 days. Give them 10 days. That is completely defensible of that position, because that falls that's what provided, because you saw those pictures, you had the testimony, but you can now say, I'm concerned that 30 days is too much time. Give them 5 days.
But how do we enforce that within 10 days?
What do you mean?
What is the enforcement to have it done in 10 days?
So if this is a first violation, if they do not come in compliance, say 10 days versus 30 days. If they do not come in compliance within those 10 days, their fines start ticking from the day of violation. So if I only give them 10 days to correct, and there's a reinspection, and they're not in compliance within those 10 days, their fines start. Whereas if I give them 30 days to come in compliance, do a reinspection, and they're not in compliance, that's when the clock starts. So we're saying you have to get this done now, or we're going to start fining you sooner. So we're giving less time, we're giving less breathing room to get this in order. Otherwise, it's going to be a daily fine. And then
be back in front of the board.
And then if they come back before the board, and just as Chair Higgins even said, that takes into those three factors: gravity of the situation. Yeah, there's a problem. If it's an issue we're concerned about children or being an attractive nuisance or could potentially cause harm, but not to the level. But we haven't had evidence of public health, safety, or welfare. You have, if it's a first violation, you have up to $250 a day. So if it's not that big a deal, $10 a day, $50 a day. If they're not taking this seriously, $250 a day. Those, as someone who has done these hearings, those fines add up real quickly. And if they want to sell this property down the line, they either have to pay it off or come before you and request, can you please reduce the fine? And then you get to ask them, why didn't you do this in time? So that is because a lot of this always, I have to remind myself of this all the time, especially because you always get lost in the minutia. But the best case scenario in every case that comes before you is compliance. That is what we want. We want, if Nick Faulkner comes up here and says, dismiss it, we're asking you to dismiss the case, we came to compliance, that is a win.
Right.
But for that fine, it goes out by certified mail? Is that the way they're notified, that they have 10 days before the fines of $250 a day starts accumulating?
Certified return receipt. It goes through the same.
And so many of these things that we listen to, they're never received. So we have no power to be able to have other means of contacting them so that this condition doesn't just continue going on. So yeah, the fines are growing and growing and growing, but that issue is still a public safety issue. It's still out there.
And that's the thing, and that's why the question, if it is an issue of a serious threat of public safety, health, safety, or welfare, that has to be presented before you, so that we need to go. And if the city feels it's that way, that's why they would provide you with that information to say, we need to go on, the city is saying, here's the evidence, we need to go onto this property if this is not corrected in time. Maybe because it's a property owner who is completely absent. But this is causing, we are concerned about the threat to public safety. They don't do it in 10 days or whatnot. We need to go on and do it ourselves.
Well, yeah, that's what I was going to say, is that, in cases where the board has articulated a potential threat and has issued a cease and desist order, or has issued a fine with a very short compliance window, maybe we need a mechanism whereby if there's been no compliance, it could come back before the board as a serious threat, and that would start the wheels in motion for an additional fine, or the city to come in and make the correction.
And in that case, ultimately, the city will run its investigations as it needs. But I mean, that if we have a compliance order that's not being met, and we have now gotten to the stage of a serious threat to public safety, they can bring another case. They can bring another case to you.
Right, and that's my point, is that, do we have a mechanism to make sure these cases don't fall through the cracks? We're just issuing $250 a day fines. Great, but is this situation getting corrected? If not, then maybe we need to come back. Somebody
And ultimately for the city, the proper procedure would be a new case.
Correct.
Yeah.
Yeah.
Joe, you had
So,
some questions.
so I have a question, and you just barely touched on what's a big trigger for me.
Are we talking about the rat house?
No. I'm going off on a completely different tangent. You used the word appear. The use of the word appear is a magic word. When we say it appears as though there is a matter of serious threat to public health and safety, you're not saying it exists, you're saying it appears to exist. When you say that there is a threat, you're making a judgment that says it exists. And this is my experience from aviation law. The Air Traffic Control Handbook is written not by air traffic controllers, but by lawyers. And every time there's an aircraft accident, lawyers get together and change the wording to try and make sure something doesn't happen again. And one of the big keys in every air traffic controller's vocabulary is the use of the word appear. A controller cannot say to a flight, Delta 1215, you're on fire. They can say, Delta 1215, you appear to be on fire. Because it's not the controller's judgment to say that airplane's on fire when it might actually be a normal occurrence. And it's the same thing here. We can't say it is a threat. It's the responsibility of the staff to say that this exists. And we can only say, looks to us like it exists. It appears to exist. They have to make the judgment that says there is a threat and tell us there's a threat, and we can say, yea, verily, there is a threat. But it's not within our responsibility to judge that this serious threat exists unless it's brought to us by the staff.
It needs to be, yes, it needs to be brought before you, because ultimately, you can, if the city were to say that this is, we are putting on evidence that this is a serious threat to public health, safety, and welfare, you can say no. And that's the thing. You can say yes or no. You don't have to, again, you can disagree with them and say that it's not a public health, safety, welfare, a serious threat. And that is because you determine whether or not, based on the evidence, whether or not there is a serious threat or there is not a serious threat. So they bring you the evidence, and then you make the determination yes or no.
But they have to present the evidence that there is a serious threat.
Yes.
And if they don't present the evidence, then we can't presume that there is a serious threat.
Correct.
I think we're also forgetting one important fact. If there is a serious threat, we're going to go criminal route, and you're going to have building officials, fire department, or police department on scene. It's not going to even go code enforcement likely.
Well, it'll probably go both ways.
Probably go both, but your situation is going to be handled before it even gets here. We hope. By some other department, and then it may come here.
Yeah. Like the one over on Santa Maria, and everybody showed up.
Thank you.
appreciate you all engaging in that Q&A because I know that this is something that has been a bit of a gray area before the board, and I wanted to make sure that we addressed it at the training. I know we are running up on time, but hopefully you feel it's being substantively spent talking about these things. So just to continue a little bit on this, it does let you know that if staff does include evidence in their findings of fact regarding a threat to public health, safety, or welfare, or an irreparable or irreversible violation, then that empowers you as the board to include in your order, if you so find, not only imposition of fines, but also, as Mr. Lewis mentioned, that next step, which is to authorize city staff to go onto the property and correct the violation. So you are absolutely allowed to consider the appearance of a threat to public safety under that sort of gravity of the violation for purposes of your compliance order timeframe and your penalty imposing, or your order imposing penalty for the fine. And I think, Dan, correct me if I'm wrong, similar to what we were talking about under the slides where it was that code board members were not allowed to initiate cases, but they were allowed to make an indication about a potential violation, and then it would be staff's discretion to pursue an investigation or not. That if you raise that as a concern under that gravity of violation factor, then it would be staff's discretion whether or not they wanted to start an investigation specifically for a threat to public safety and welfare. If so found, they would put that in the affidavit, that would come back before you, and then with the presentation of that evidence by staff, you would then be empowered, if you found that there was that violation, to include the next step in your order, which would be to allow city staff to go onto the property to correct the violation. So that, I think, is kind of how that order of operations would work. But again, yes, I think ultimately what we were talking about here is that if you have a case before you for missing screens on a pool enclosure, it would be beyond your scope at that point to say 10 days of compliance, otherwise city staff is going to go in and fix that. That's where the issue is. That second piece, otherwise city staff is going to go in and fix that. You are not empowered to make that part of your order unless city staff has brought the evidence of a threat to public safety or welfare and you agree with those findings of fact. Is that accurate?
That's yes, exactly.
Okay.
That's the way I would phrase it.
All right. So now we move on to everybody's favorite topic, the Sunshine Law, which applies to any 2 or more members of the same elected or appointed board and prohibits you from discussing board business outside the confines of a public meeting that has met the notice requirements, which has met the requirements under the Sunshine Law, which is that it has been called to order, it has a quorum, minutes are taken, and the public has been provided notice of that meeting. So some of the things that we wanted to point out under Sunshine Law is that best practices include no discussion of committee business before the meeting is called to order. So just because you're in this room and all together, if the meeting hasn't started yet, if it hasn't been called to order, if the board reporter isn't here to start taking the minutes, if you're still missing one board member and you're not at a full quorum, then it is still outside the confines of that meeting, and it is technically a Sunshine Law violation to start talking about board business before that meeting is called to order. Similarly, after the meeting is adjourned, sometimes board members, have questions for city staff. I would caution you that for example, if 2 or more of you have a question for city staff that is either about cases or updates, things like that you may want to be a little bit wary of that, because even though Sunshine Law doesn't prohibit you from communicating with city staff, if 2 or more board members are involved in that conversation and it's outside the confines of a public meeting and it ends up veering into the realm of board business that may come back before you when the meeting is in order, that could be an opportunity for a sunshine violation. So just want to point out those sort of right before and right after, that those time frames are times to just be cognizant of, because you are still all in a group, and you are still all in the meeting space, but sunshine law prohibits you from having those conversations because the meeting itself is no longer going on, if that makes sense. And then, as we mentioned at the beginning, in terms of the sidebar conversations, and really the issue here is I don't think it's a situation where we are having board members, having communications over their shoulder with other board members about board business, but it goes back to that appearance. If it's not on the record and we can't hear what you're saying, then it's less defensible. So if you have a question that is just an administrative or procedural thing, ask it into the microphone, and either the board attorney, the city attorney, or city staff, whoever's the appropriate person to respond to that, can give you that information. Oh, and then I did also want to point out that when it says may not discuss committee or board business, that it doesn't it's not restricted to just what's on this agenda before you this date. It is, stuff that could reasonably come before you again, stuff, so that includes potentially past cases, present cases, cases that may reasonably come before you in the future. So it's broader than just what's on the agenda for this meeting. I know everybody's favorite thing to do with sunshine law is to pose hypotheticals. We love hypotheticals. Call up city staff and ask your hypothetical so we can get you a determination on that, because it really is very case specific and case dependent on a sunshine law violation. And we can provide sort of these general guidelines, but if you have a particular instance or a particular, like I said, example that you would like determination on, hey, if this happened, would it be a sunshine law violation? Feel free to pass that along to city staff so we can get you that information. I personally feel work better by example, so I like having that stuff so that I know exactly how it applies in some of the situations I may or may not find myself in.
Before you move on,
Sure.
the telephone participation, if I read that correctly, that person on the telephone would not constitute a quorum if needed.
Correct. And so
What
right
about
now,
Zoom? Now, the new thing called Zoom, what if that was?
no, as far as I understand, quorum still relates to physically present. And when we were in the Military Heritage Museum, we didn't have the set up to accommodate remote meetings. That's not, as far as I'm aware, it's not the plan to have that set up, so that we don't run into a potential issue with sunshine law. So for the foreseeable future, remote participation for purposes of sunshine law and quorum will not be allowed, and it will be physically present for the board meetings.
Sorry to keep butting in. Quorum, it requires physical presence. You have to Zoom, regardless of any technological advances, unless there's another COVID. That's our kind of bar. The Florida statute, it has to basically be an emergency situation that we cannot physically be in the same room together. But otherwise, quorum requires a physical presence of the majority of the board. So we need four live bodies sitting here to constitute a quorum. Now, if someone else wants to join in beyond the four, that could be allowed, but how my firm and how I always usually handle it, I have a motion and vote to participate electronically for, say, that fifth, for those additional members. But if we're going to have a quorum, we need four physical people together to actually go forward with
And
official
that's
action.
clearly spelled out in the sunshine law.
Well, that is Florida statute for open and public, for sunshine laws, for open meetings.
All right, and then just the last point that we'll reiterate here under sunshine law is about videotaping of a public meeting by somebody other than city staff. Obviously, we do our audio and video recordings for the record and to assist our board recorder in preparing the minutes. If a member, these meetings are open to the public. Just because we don't allow public comment doesn't mean that they're not open to the public. Those are kind of two separate things. So it's open to the public in the sense that it's been noticed, it's been called to order under the requirements of the sunshine law for a public meeting. So if a member of the public wants to videotape the meeting, they are within their rights under the Sunshine Law to do so, as long as it is non-disruptive and silent. If it starts interfering with board business, then that becomes, you know, a conduct issue, and there are steps that you can take. The chair could recess the meeting, adjourn the meeting, those kind of things, or if law enforcement needed to be called to remove that person from the premises, then, you know, that's an option as well. But if they're just standing in the back silently videotaping a public meeting, that is perfectly permissible. And I just want to make sure everybody's aware of that, because even though it can be uncomfortable, doesn't make it illegal. Then under public records laws, as you all are aware, public record is a pretty broad definition. It's based on the format, not the content, or excuse me, based on the content, not the format of the record, and really encompasses any material made or received in connection with official business used to perpetuate, communicate, or formalize knowledge. For the most part, the documents, the records that this board deals with are already maintained by the city. The things that are contained in your agenda packets, all of the, you know, the case orders, all of that documentation, email correspondence, or written, you know, correspondence with the respondents, all of that stuff is maintained by the city. The only thing that you as board members have to worry about is if you are communicating outside of a city staff person about board business, then, or, excuse me, if you are well, you shouldn't be communicating with other board members about board business, because that's a Sunshine Law violation. But if there is anything, like the social media posts is kind of the go-to example, because that's created by a board member. You're allowed to do it. It's just that it becomes a public record if it's related to city business, and then it's the board member's responsibility to retain that. Record and make sure that it's saved, you know, in compliance with the retention schedule set forth by the state. So basically, if you have questions about any documents or records under your, you know, within your custody, as to whether or not those are a public record, reach out to city staff. You can always forward it to, I think there's, yes, this retention@cityofpuntagordafl.com email address, because that will automatically put it into our archive system, so it will be retained. Generally speaking, like I said, you guys aren't going to have to be concerned about producing things that are public record, but if you do have questions about it, please feel free to reach out to us, send a copy of it to that retention email, and do not communicate with other board members via email. Not because of a public records issue, but because of a Sunshine Law issue. Okay. And then, I promise this is like the last 3 slides. Under ethics, this is where we're going to talk about the conflicts of interest. So earlier we spoke about where you had the option to recuse yourself from deliberation and ruling if there was, you know, an impartiality or fairness issue under due process. That's an option to recuse yourself. If you have a statutorily defined conflict of interest with a case, then you must, at that point it becomes a mandatory requirement to recuse yourself. And you have to submit a form to the city clerk's office that identifies what that conflict of interest is and what item it is that you're recusing yourself from. So this slide will give you the definition of a conflict of interest. Basically, any special loss or gain based on your relation to individuals or organizations involved in that case. And that Form 8B is the form that you have to submit to the clerk's office. If you do abstain because of a conflict of interest, that's available through the Florida Commission on Ethics website, that form. It's also the same place where you submit your financial disclosures, which is the next thing we're going to talk about. So this being a decision-making board, you all are required to file the Form 1 financial disclosures with the state. It's done via an online portal, so when you sign up to be on the board, you get information on how to create an account for that portal, and then it will send you a reminder every year when you need to submit your annual filing. When you leave the board, whether you resign, term out, opt not to serve another term, anything like that, you do need to submit a Form 1F, which is your final financial statement, basically saying, I'm no longer on that board, this is the last time you're going to get any of my information, and here it is. So if you have questions about submitting those filings, or if you haven't received, usually they send those emails out because the filing deadline is July 1. So usually they start sending out those reminder emails, I believe, like mid-May through June. So if you aren't getting those, it might be a good idea to just reach out to our office so we can make sure that they have the correct email address for you, because there can be fines imposed for not filing those within the required time frame. Okay. Any questions on financial disclosures, sunshine law, public records law? All right, excellent. Well, that concludes our training today. Thank you all so much for being very active participants. I know city staff appreciates it. I feel like we are all on, on the same page now about a lot of this stuff, and I hope that it will add to the expediency and efficiency of this board. You guys are doing a fantastic job. I appreciate it. I know that this is one that has a lot more procedures and processes than some of the other boards. So thank you all for being cognizant of those and dedicated to being in compliance with those procedures. So, all right, thank you very much.
Thank you.
Thank you.
Thank you. We really
Thank you.
appreciate
Yeah,
it.
thank you.
I know this
Nicely done.
was a lot of work to put this together, and we appreciate the dedication that the staff has put forward in doing this, and not incidentally, the dedication that the staff has put forward in presenting the cases. I mean, they do a really phenomenal, marvelous job, which makes our job a whole lot easier. And so we thank you for that every day. Anybody else from the board have any comments on the training?
Do we get a certificate for this?
Yeah. Okay. Okay, I
I'll
think,
make you one.
Oh, thank you.
oh, thank you. Okay, we're
In
to,
color.
in color, yes. We're to staff comments.
Yeah, I just wanted to add a couple things. One thing with the repeat violations, I'm sure this information would have overloaded the slide, but just for additional informational purposes on repeat violations, say a property, you have a cease and desist for tall grass and weeds. And a month later, they again have tall grass and weeds, but also we find outside storage. That would not come back to you as a repeat violation because of the outside storage code, which does not have the cease and desist label, and due process has to be carried out for that outside storage code. And then maybe it'll be in the minutes that city staff will go and correct the violation. City will hire contractors to go and correct a potential violation that is detrimental to the public safety and welfare. And there is a difference in the distressed properties versus the properties that have a potential public safety issues. Distressed properties are properties that the city contractors go in on our behalf or our request to go in and mow the grass or to trim overgrown shrubs or remove landscape debris. That's it. If anything is needs to be repaired as far as like pool enclosure screens or a roof that is has or whatever kind of violation that is a public safety issue, that decision has to go through city council first before we can send anybody to go and repair that property. That's all I have.
Madam Chairman,
Yes, sir.
I've got a question, and I want to thank staff because, full disclosure, this is only my 4th meeting as a board member. 3 of them I'm an alternate. The first meeting I attended was as an alternate. The last 3 as a board member and voting member. I never did understand the attendance of the attorneys, nor did I know until today that we have a board attorney and a city attorney. In the past meetings I did attend to, the city attorney seemed to address the board more so than the board attorney. So I guess my question is, or if I understand correctly, the board attorney advises, the city attorney prosecutes if need be. Is that correct? Why do we have 2 attorneys at our meeting?
So that is a very good question, and the reason that we have the two is because of due process and conflict of interest. That it would be inappropriate for, in the context of a case, for the city attorney who is representing the city for purposes of those violations, for him to also be advising the board on how to consider the evidence that was presented and how to consider the criteria under the Code of Ordinances to apply their deliberation and translate that into a ruling. So that's why we have two, because in the context of the case, the city attorney is basically going to be representing the city. He has a stake in the game, just like city staff does. So for him to both, or the city attorney to both advocate for the city's position and presentation of evidence, and also advise you as the judges on how to consider the evidence he or she is advocating for, that would be inappropriate. So that's why we have two. And previously, outside the context of a hearing, there are often times where in prior board meetings, the city attorney has provided information on process and procedures to the board, which he's perfectly allowed to do in conjunction with the board attorney. It's really just for when we, in the context of a case that is being heard, we have to have the separation between the city attorney, who basically is advocating for the city's presentation of evidence. In the event that the board has questions during that hearing, it's more appropriate for the board attorney to answer those, because the city attorney can't be telling you all how to interpret the evidence that he is advocating for, if that makes sense.
And just to refine Jen's point, because she's 100% correct in everything she said, just how to refine it how it's in the city code. Essentially, you can be a player or you can be a ref, but you can't be a player and a ref. Is basically how it breaks down to. Under the code, the city attorney can either be a prosecutor or he can be the board attorney, but he can't do both. And if there is a situation where a case, say a respondent has their own attorney, because at that point, if the city attorney is stepping into my role as your attorney, the board's attorney, essentially being the ref, that leaves city staff without an attorney. So city staff would have to present the whole case, evidence on their own, or hire a separate attorney for that as well. But again, the whole point is I can't be a player and a ref at the same time, because it essentially is like, here's the evidence, and here's why I think you should, and here's how you should look at said evidence. So so essentially it's skewing the game in favor of the city as opposed to being fair.
Thank you.
Any further staff comments? Any member comments in general, not necessarily on the training? All right, and there's no further business, all right, we are adjourned.